All right, friends, let's change it up. New contestant up with Judge Culotta in Lake County, Ohio. Let's go there.
Thank you, Your Honor. It pleased the court, we're before the court this morning in the matter of the State of Ohio versus Martin Martinez, case number 25-CR-1102. The defendant is present in the courtroom with his attorney, Mr. John Fatica. We're before the court this morning for purposes of sentencing, the defendant having pleaded guilty and been found guilty of one count, theft, a felony of the 5th degree. Parties are ready to go forward, Your Honor.
Thank you, Mr. Fatica. Any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, I'd like to start off by saying that Mr. Martinez understands he used very poor judgment not to show for his PSR. He did turn himself in voluntarily. 34 years old. He's currently employed as a laborer for Deck Rescue. He has 6 children. The youngest of his children, both under 2 years of age, live with him and his fiancee. He has 16 days of jail credit as of today.
How many?
16.
16. I thought you said 60.
No. We've submitted a number of letters that demonstrate that he has supportive family and friends. He's been active in AA. He's been a sponsor in the past. He relapsed here. And again, we understand that the court's options are limited, but we'd ask for leniency. Thank you.
Mr. Martinez, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah, I wanted to apologize to the victims. I know they're not here. Mike and Anna were very kind to me in my life and provided me with an opportunity when I was in early recovery several years ago. I don't know where things went wrong, and I don't have an excuse for what I did for them. And I hope I can make restitution and a personal amends to them. I'd also like to apologize to my family sitting over there. They've stood by my side for 20 years of addiction. And even with the good years, I know there's always that anxiety of the next relapse. And I just love you and thank you for always being there for me. I'd like to address to you, I'm sorry I didn't show up. I wasn't in my right mind. And I just want to put this behind me. That's it.
Fatica, anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. DePiro for the State of Ohio.
Thank you, Your Honor. You know, Mr. and Mrs. Day are not here today, but I'll tell you, Mr. Day was here the last time we had a sentencing set in this matter. He sat in that hallway and he waited patiently to express to the court how the defendant's actions have hurt he himself and his wife and his business. The amount of restitution here is $6,006.07.
6,006?
Yes. That's what we can show. That doesn't include the times that the defendant is seen on video reaching his hand into the shared tip jar and taking cash. That also doesn't additional conduct that the Days just simply didn't have time to scrutinize. The Days were very active and helpful in submitting documentation of the theft to the Mentor Police Department, Your Honor. And Mr. Day put together a spreadsheet that delineated every single time that the defendant stole from them. There's 188 entries in those months of time. And every single one, the Days looked at the video, documented it, wrote it down, so that we could prove that the defendant stole this money, which was not an easy task. And that took a lot of effort on their part. Over and above being victimized by the theft, they had to do all that. Mrs. Day confided in me that they had a prior incident with the defendant where he was stealing from them, but they gave them another chance because the Days know that the defendant has children to support and they did not want the defendant's children to suffer. And he just talked them into that he's a decent guy and that he should get another chance. Mrs. Day does not feels very strongly that that's not the case, that this is not a situation of a good guy with a drug problem. This is sustained criminal conduct that hurt them and is worthy of incarceration and punishment. The defendant does have credit for 16 days. Thank you.
Thank you. This court has considered the facts and circumstances of the offense involved, the nature of the offense. I don't have a pre-sentence report to consider because the defendant failed to appear at the probation department for his interview and for the preparation of the pre-sentence report, so one was not able to be completed. I did receive a victim impact statement, and I've read and considered what the victims have had to say. I received multiple letters in support of the defendant from family members, acquaintances, and I've read all of those and taken those into consideration. I've considered what's been said here today by the defendant himself, his lawyer, the prosecutor. All this is considered by the court and by the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, the court finds in regards to the factors that make the offense more or less serious. That the victims in this case not only suffered serious economic harm, but also emotional harm. They entrusted the defendant, and he violated that trust. The economic harm, as alluded to by the prosecutor, is not the only loss they had. They spent hours and hours putting stuff together and researching and investigating what happened here. The defendant's relationship with the victim facilitated the offense. The defendant had a position of trust with the victims in the business there and used that position of trust to commit this crime. No factors indicate that the offense is less serious than normal. This took place over a 7-month period of time. This wasn't just a one-time incident that occurred, which is what most offenses are. This was 7 months of planning and scheming. Every time money is taken, it's a crime itself. It's planned out and it's schemed, and the cover-up has to be involved. And he did this over and over and over, 180 some times, at minimum. And they trusted you. They helped you. They gave you advances on your pay every paycheck almost. Because you talked about how you were in financial need and dire straits and you had kids to support. And they went out of their way to help you. And that's how you treated them. No factors, again, make this less serious. As for recidivism factors, the court notes that the defendant has a drug abuse problem. I don't know if it relates to the offense or not. But he hasn't done anything to address it. 20 years. I think one letter mentioned 18-year opioid addiction. He mentioned 20. He hasn't done anything to address it. He violated the conditions of his bond in using drugs while on bond and failing to appear for the probation department, failing to appear for his sentencing, even though he turned himself later in that day. He wasn't here for his sentencing. Factors indicating recidivism is less likely. The defendant doesn't have any criminal history. He's led a law-abiding life for a significant number of years. In terms of any convictions, he's been using drugs for 20 years. And obviously that's against the law, but he hasn't been convicted of any offenses with that. problem here is that you didn't show up for your pre-sentence report. And you were specifically advised when we were here last time that in order to be considered for probation, a pre-sentence investigation had to be completed. And in order for a pre-sentence investigation to be completed, an interview with you had to take place. And you were specifically told if you fail to show up for that interview, probation cannot complete a report, and the court doesn't even have the lawful authority to put you on probation. And you were also told that if you, the court will not continue the sentencing to some later day to get the report done because it wasn't completed initially due to your lack of cooperation. And you even mentioned about how you had used shortly before that. And I specifically even told you, I watched the video before I came out here at the last hearing. I go, even if you're afraid of being arrested, you need to show up. It's important to show up no matter what. And you didn't show up. So I can't put you on probation. I don't have the authority to do it. And you were specifically told that. And you made that conscious decision not to do it, not to come in. And even in this case, you were supposed to show up on December 22nd. You didn't show up to probation. They contacted you and they spoke to you. And they rescheduled it after the holiday. So if you would have gone on the 22nd, you would have been arrested. Wouldn't have been able to spend the holiday with your kids. But they let you then give you another week. To December 29th. So if there was a warrant out for you, you could have been home with your kids for the holiday and still gotten your pre-sentence report done. Now, they didn't ask me about that beforehand. I don't know if I would have allowed it, but they allowed it. And you didn't show up on December 29th. So when you talk about wanting to spend holidays with family and kids, there may be something to that. But then December 29th rolls around after the holidays and you still don't show up. And December 30th and January 1st and January 3rd, you don't show up. That's a decision you made. Knowing the consequences, that's a decision you made. So there's nothing I can do about it. I'm not going to continue the sentencing to a later day to get a report done because you chose not to. You don't want a report. It's the only thing I could assume. I've been doing this for 22 years, and I've done that all the time when people don't show up. And there's no reason to create some exception in this particular case. So you violate the conditions of your bond. Prison's consistent with the purposes and principles of sentencing. And if you can't show up to the probation for a simple interview, I can't find you're amenable to probation. I mean, that's one of the basic conditions is you have to report to your probation officer, aside from whatever other conditions have to be followed. You can't use drugs. You use drugs. When you turned yourself in, you're positive for cocaine, marijuana, and fentanyl. So you're using this whole time you were out.
I have a drug problem.
So violate the conditions of his bond. Prison's consistent with the purposes and principles of sentencing. Again, the defendant is not amenable to any available community control sanctions. You know, the offense here, it's not just a possession, a drug charge. You stole from people over a 7-month period of time, thousands of dollars. There deserves to be consequences. Therefore, as a sentence to this court that on count 1, defendant serve a term in prison of 9 months. He has credit for 16 days he's already served. I need to advise you upon your release, you could be placed on post-release control for up to 2 years. If you are on post-release control and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. Defendant's further ordered to pay restitution to the victims in the amount of $6,006.07 to be reduced by any amount that the victims may receive from insurance proceeds. So I know a claim was made. It hadn't been resolved by the time of the victim impact statement. At a minimum, it'll be a $1,000 deductible, but I'm putting the full amount now, again, to be reduced by whatever amount is received from insurance proceeds. I think that covers everything. Mr. Patapiro, anything else for the record?
No, Your Honor, thank you.
Mr. Fatika?
No, thank you, Your Honor.
All rise.
All right, good luck.
But however you slice, dice, and julienne fry it, it is not. It's not sustainable, and we can't keep doing this as a society. So those are my thoughts on that one. Head southeast over to Lake County, Ohio, and Judge Culotta. So if you recall that case, that was the drug addict guy. Now, if I recall, he said he was 20 plus years into his addiction issues. He has kids because he was worried about not being there for them. And he was stealing from the place where he worked to the tune of $6,006.18 or something like that he has to pay in restitution. And this guy, he committed the cardinal sin that we constantly talk about here in so many ways, and that's just show up. All he had to do was show up, and he didn't show up for his pre-sentence report, the pre-sentence investigation. So the option of even giving that guy any kind of probation was taken off the plate for the judge. By law, according to what the judge said, he was not allowed to actually consider him for probation because the pre-sentence report was not done. So again, people acting fools. And the one thing, he had one job, show up, and better things probably would have happened. But he didn't. But here's the thing, 9 months. He steals over $6,000 from people who are trying to look after him and trying to take care of him because they'd mentioned that they were constantly giving him advances on his salary and stuff too to try to keep him going. And he's still stealing from them. But there, we only see 9 months. I don't know if that's, we've talked about that before though. I say I don't know if it's enough, but in the same respect, we've talked before about how if these people who have the financial crimes, if they're put in jail or prison for too long, then it makes it harder for the victim to receive any kind of restitution. Plus, they don't receive restitution with any kind of interest, which, just means that, and Judge Stevens has references in his court where they're losing the ability to use that money, and the value of the money keeps going down, especially in the current economy where inflation is kind of out of control still. I don't care what anybody says, it's still a problem. So they're losing the value of all of that money the longer it takes for them to get their money back, which sucks. So I'm really torn on that one. If you've got other thoughts, tell me, but there's a part of me that feels like he should have gotten a lot more, if for no other reason than if he's in prison for a couple of years, maybe fingers, toes crossed, he could get enough services to break that addiction situation. But in the same respect, I realize that the longer you leave him in, the harder it is for restitution to happen. But this is another one to me that speaks to the concept of drugs not being a victimless crime. I know that a lot of you out there disagree with me on this point, but I am staunchly anti-drug, and I'm not going to claim that I'm not. I line up much more behind the Judge Elmores of the world, who has flat said to people, I'll take on anybody in a debate about whether or not drugs are a victimless crime. Because here you've got a drug addict who's going to jail for 9 months, which means his family is without him, his kids are without him, his employers are without their $6,000 because he's out there doing drugs and being a fool. So there are definitely victims. We can claim all day long that we don't care what somebody does with their body and what they put into it. And that would be great if that person was in a vacuum. But they're not. They never are. Because you can't go through society. You can't live on this planet without interacting with others. So your actions at some point end up affecting others no matter what we do. So I don't know. Again, another person acting a fool, and this is just not sustainable.